Liberty Nation with Tim Donner.
Welcome back to Liberty Nation Radio. I'm Mark Angelides. Now, with a fresh tilt on the Supreme Court, expectations have been high for conservatives that new blood would deliver. Guns and abortions are both on the docket this season, and to help us unravel, indeed cut through the Jordan knot that is jurisprudence in the United States, is host of the Uprising podcast and Liberty Nation's legal affairs editor, Mr. Scott D. Cosenza, Esquire. Thanks for being here, Scott.
Hi, Mark. Thank you.
Now, Scott, for the last, I guess, 5 years, we've been hearing that Roe v. Wade is on the chopping block. Doubtless, this was used by both sides of the political divide to raise funds, to demonize their opponents, to drum up enthusiasm within their base, or indeed anger within their base. But there is a case heading to the Supreme Court right now that actually could have an impact, unlike all of the rhetoric of the last 4 or 5 years. Can you fill us in on the details of this, Scott, please?
Well, yeah, and what's happened in the past few years forms a basis for this, which is to say that there's been a concerted effort by all those forces you mentioned to advance restrictions on abortion for all the benefits that it confers, meaning from the genuine belief that, of course, for those on the pro-life side, that there is a life that's being extinguished. So for that benefit, all the way through to just the additional fundraising, direct mail campaigns that people who are in elected office that get to sort of lift themselves up on the pro-life platform can gain from that. But we've seen in Mississippi a restriction that's going to be before the Supreme Court in the fall, Mark, and it has the potential, like you say, unlike some of these other cases, this is real. This is about the Supreme Court taking the case to address a question that could result in the overruling of Roe v. Wade. And that's why. And the question is whether or not pre-viability restrictions on abortion are constitutional. Before this case is heard, the ruling has been that any restriction on abortion that significantly impacts it, that is pre-viability, which is to say before a fetus or baby or whatever can live outside the womb, that has been unconstitutional. We may see a new ruling now, and of course, the anti-abortion people are fingers crossed and praying that that this will somehow, be an end to the significant rights guaranteed by Roe v. Wade and Planned Parenthood v. Casey, and some fundamental restriction on abortion that we haven't seen since 1973, basically. And of course, the other side is scared that might happen and are fighting against it.
So, what this decision, this Mississippi decision, would mean is not that all of a sudden the process as it is now stops overnight, but rather that it creates a wedge effect?
Well, we don't know, Mark. See, the thing is, once the Supreme Court gets to examining a sort of core question about it, what their result could be anything from 0 to 100. And what I mean by that is, and let me just, before I state my analysis of it, I don't think that we're likely to see the most radical of changes, because both on the left and the right, the court is generally a conservative body. And whether justices feel one way or another about a rule or law, they generally disfavor radical changes in the law. They favor much more glacial changes in the direction that they sort of prefer. So that said, the Supreme Court could declare that with new technology and understanding of human development, that fetuses are human beings and have a full suite of rights, just like a born person has, rather than the unborn, and that abortion is illegal at a certain point, maybe even only weeks or a month in. That's a possibility. I don't think that's likely, but it is a possibility, all the way through to a restatement of a Roe v. Wade and Planned Parenthood v. Casey restriction, which is to say they could say any pre-viability restriction is unconstitutional. Now, the question then is, if they wanted to do that last part where they just said it's unconstitutional, why take the case? So that's why there's so much hope on the anti-abortion side, like you opened the segment with, talking about basically how the conservative justice is going to pay off, right? The thinking is they only took this case for one reason. They want to make a ruling that's more restrictive on abortion. Otherwise, just let the precedent stand.
Do we know? We know that it takes 4 justices to agree to hear a case, but we don't know exactly how many chose to hear the
We
case.
just know that it's at least 4. That's right. That's exactly
4.
right.
Okay, Scott. Let's move on to the other of the big beast constitutional questions, the Second Amendment. Now, across the nation, we have seen laws, bills, initiative, measures. They're coming out at quite a pace. Some seeking to strengthen the right to keep and bear arms, others to weaken it for whatever reasons they see, whether it's a public safety, a greater good reason, whatever those reasons happen to be. But it is at SCOTUS where the decisions will ultimately be made. And there's a gun case in the offing. Can you tell us a little about that, please?
This is a case out of New York where the Supreme Court has said it will decide whether or not the decision to basically restrict the right to keep and bear arms from carrying is unconstitutional or not. The gun rights people, and I count myself among them, Mark, are hoping that the Supreme Court articulates a bright line standard that states have to recognize the right to carry a firearm included in the bundle of rights incorporated and included in the Second Amendment. That hasn't been decided yet. Right now, the position of the Supreme Court is that Americans have a fundamental right to keep and bear arms in the home, but they don't necessarily have a fundamental right to carry firearms if the state has certain regulations that frustrate that right. New York is perhaps one of the worst states to try to get a permit or a license to carry a gun. It's generally only given to politicians and those with political friends. And
Scott,
this case,
am I right in thinking that in New York they have a may issue rather than a will issue?
And shall is what you're thinking of rather than will. Right. Yes, that's exactly right. This is may issue versus shall issue, and that concerns the discretion that government agents have. Whether a may issue state is you go and you present your credentials. If they meet the requirement, they're required by law to give you the license or the permission slip. And in a may issue state, they can still say no if they don't like, for whatever reason, anything that you're doing.
So that would be, I mean, correct me if I'm wrong, I am not a lawyer. I'm certainly not a constitution lawyer. I'm not even an American. But would that be, for example, I
only count 2 of those against you, by the way. Okay, one is for you.
Not being a lawyer, of course. Would that be that a clerk in a county office, for example, or the head of that department,
it depends,
determining how the Constitution is applied?
It can be a clerk in a department. It's different in different states. This is a New York State case, but it will apply nationwide. I happen to know in New Jersey, for instance, it's chiefs of police and judges who are involved in that decision-making process. So the point is that it's somebody that you have to convince or gets to make a decision based on their own just seat-of-the-pants judgment, not applying an objective standard, which is how I think most Americans think that our rights,
well, I mean, if it's written in the Constitution, you would imagine that that's how it is. Now, just to come back to the broader question there. So this is about being able to carry a firearm rather than being able to own or possess.
This is about permission to carry a firearm outside the home. That's exactly right.
Now, I did used to be an English teacher. So perhaps I have an advantage on you over this, but not when it comes to the legal elements. But to bear arms, to bear usually means that
Mark,
you
let
have
me just
them
stop you
on
right
your
now.
person.
Let me just stop you right now and say that if you think that the plain language of a constitutional amendment is going to control how a justice rules on the constitutional amendment, I think you're already down the wrong path there.
Down the rabbit hole, which is a podcast you should listen to. All right, Scott. Now let's move on from that. You obviously, Scott Cosenza will be keeping everybody updated on the pages of libertynation.com on how these cases progress. But let's take a look at what else is on the SCOTUS docket. Now, you do keep a close eye on this. You have me on the phone on our messaging every Monday morning saying this thing's coming out today. This thing's coming out.
Well,
today.
When there's opinion release days,
yeah,
that's right. Yeah.
So what cases of interest are coming up for those people with a more conservative bent?
Yeah, and I think I just want to focus right now on a case that I don't think that's going to come up, which is the Florida restriction on tech companies banning elected officials during their time in as they run.
This is just for those of you who may not have caught this yet. This is Ron DeSantis signing a law.
It's a law that produces fines for social media companies if they deplatform declared candidate for elective office. I think within 4 months or so. Anyway, there's a set term for which they can't do so.
So we're fairly sure that in the run-up to 2022 and 2024, Donald Trump will be applying to be the state head of dog catching in Florida, and he will be on social media, or he will be collecting. I believe it's 100.
That's kind of brilliant.
He'll be collecting $100,000 a day from the
social media
that
won't happen.
Or he'll be dog catcher.
So the law author, I do like that kind of end run though for him, like just to try to run for some very low level office in order to secure his Twitter credentials back. But I'm confident.
For those of you who have been asleep for the last 5 years, Donald Trump is willing to troll the entire world. Yes,
I don't think that's going to happen, because I don't think that the law is going to pass constitutional muster. In fact, I want to check my watch to see if it's been declared unconstitutional just yet. It seems like a blatant trampling over the First Amendment and an attempt to single-handedly convert a social media company into a kind of public square or government body. Even the language in the law or discussing about it, Governor DeSantis declared that it was viewpoint-based discrimination, for instance, which is totally inappropriate and illegal for government bodies to do. But for everyone else, it's appropriate, and we do it all the time. You don't hang out with people who think that you should be killed for your your political beliefs. You viewpoint discriminate.
Not that I know of, Scott.
Against those people. Exactly right. As do we all. So the idea, I find it troubling, the notion, without announcing up front, that we're looking to engage in a kind of sea change of how the law approaches a certain thing. And let's debate that. I find it off-putting. It's totally anti-freedom and anti-business in the sense that I think it's a real wedge issue between libertarians and conservatives. The idea that the governor and the government of Florida should tell any business how they should operate, who they should allow as customers, I think is anathema to freedom in the free market.
Who are we? We are Americans that believe in liberty. We are a project of the nonprofit One Generation Away. We are patriots who apply the founding principles to the issues of today.
And they keep moving the goalposts on us.
We are educators and commentators who love America and the Constitution. Who are we? We are Liberty Nation.